Hello and welcome to Advoclasses. I am Advocate by name, title and profession. The purpose of this channel is to allow me to record my thoughts and discuss legal matters, political matters, and anything else that I find to be particularly interesting. And what an interesting thing dropped last night. Like many places in the world, South Africa, where I'm from, is experiencing lockdown due to the COVID-19 virus. And like many other places, there have been regulations to keep people safe and from spreading the virus further than it needs to go. If I were being kind, I could label our regulations as being draconic, but I'm not in the business of being kind. Naturally, this sort of highly oppressive regulation tends to cause a bit of kickback amongst us rank and file of the citizenry, and such kickback generally comes in the form of court cases. And on the 2nd of June 2020, it happened. Finally, one of these cases succeeded. You'll forgive the mirth in my voice. I'm not a big fan of governments. They exist to serve a purpose, but my thinking is that they shouldn't be bigger than they need to be. And this sort of dramatic overreach as was enacted by our government is anathema to my perspectives. But I digress. As a quick summary, and lacking all the juicy details, the High Court of South Africa, Gauteng Division, Pretoria, has found that the regulations drafted by the Minister of Cooperative Governance and Traditional Affairs are unconstitutional. The obvious question now is, what does this judgment mean? How does that change things? Unfortunately, for the next 2 weeks, not very much can change. And that's 2 weeks at a minimum, mind you. We should also think about what will happen outside of courts now that this judgment has been handed down. Some are calling for the resignation of the Minister of Cooperative Governance and Traditional Affairs, and rightfully so. But will a resignation actually materialize? One must remember that we are dealing with the African National Congress, a party who is effectively scandal-proof and doesn't really care about these sorts of things. To illustrate, Dlamini-Zuma was found to be incompetent by the Constitutional Court. At the time, she was the Minister of Social Development and oversaw the disastrous implementation of the SASSA grants. The highest court of our country found her to be incompetent at her job. In any normal democracy, this would have been such a scathing finding that the minister would have resigned outright, and if she did not, she would have been fired. But South Africa does not have a normal democracy. So, rather than being fired as she should have been, or resigned, which would have been the right thing to do, Dlamini was moved and appointed as minister in the presidency responsible for women. My point is therefore this: if a declaration of absolute incompetence by the highest court in our country cannot move the ANC to get rid of one minister, is it even reasonable to expect the ANC to take actions where another minister, this time Dlamini-Zuma, has her regulations declared unconstitutional? For once, perhaps. See, Dlamini-Zuma is an erstwhile opponent of the current president. Before the president was elected, it was between Dlamini-Zuma or Cyril Ramaphosa as to who would lead the country next. Now, Cyril won, but it wasn't by the widest of margins. I suppose time shall tell, but I'm not overly optimistic. The ANC has a habit of rewarding loyalty, compliance, rather than skill or integrity. But what did the court actually say? What did the court find? I've seen and heard a few other commentators touch on the court case itself, and I found their explanations to be lacking at best and simply wrong at worst. So I decided I might as well raise my views as well, so at least there's one correct version of it out there. Right, another thing that I saw from my co-commentators is that many of them seem to be relying on the media version or the media releases of it. Well, I think I shall go into the papers themselves and see what the judge actually said. And having actually read the judgment, it's hardly as groundbreaking or as vitriolic as people make it out to be. Not to say that it's a bad judgment. I mean, I do have two criticisms against it. Now, bearing in mind that these criticisms are quite mild, and one should take into account the fact that this was an urgent matter, it means that there wasn't exactly a lot of time to think or ruminate or fix or draft or redraft, so take it with a pinch of salt. My first complaint has to do with a myriad of spelling mistakes, capitalization mistakes, grammar mistakes, punctuation issues. But again, this was drafted in short order. Even my drafting is not immune to these sorts of errors. We are human after all. Soulless, but human. And considering the tight time frame that this was all done in, it is excusable. My second and more serious critique is that I feel the judgment is lacking in clarity. I would have preferred it to be more specific, concise, and precise. But again, urgent matter, not a lot of time. So I get it. Right, into the paperwork we go. In the matter between Reino David de Beer as the first applicant, Liberty Fighters Network as the second applicant, Olabon Renaissance Foundation as amicus curiae, and the Minister of Cooperative Governance and Traditional Affairs as the respondent. Judgment was handed down by Davis J. For the record, the J stands for judge. AJ stands for acting judge. I found this out while studying. I thought it was just a big coincidence that so many people with the initial J became judges. I'm smart, I swear. Okay, back to it. This matter was brought as an urgent application. That means that the normal time frames and rules don't apply. The fact that this matter was heard, within a few weeks of it being initially filed, is nothing short of extraordinary. For the sake of context, had this been brought in the normal course, an opposed motion of this nature, assuming it proceeds as such, would probably have been heard sometime just before the heat death of the universe. Jokes aside, it would probably have been heard within about 2 to 3 years after date of initial filing. And that is on the assumption that it remained a motion. If it was an action proceeding, we would have been looking at 4 to 5 years. So when I say that this is an extraordinary matter, it is. Not that urgents aren't heard every day, but an urgent against the state on a constitutional issue might legitimately be a once-in-a-lifetime situation if it wasn't happening again next week. If nothing else, COVID has been causing some significant judicial efficiency, but I digress. The first thing one needs to prove when bringing an urgent application is urgency. In other words, you must provide reasons to the court as to why this matter should be heard on an urgent basis. Roughly speaking, the test for such a thing is that the effluxion of time would render any remedy provided by the court moot, or in normal human language, if this takes 4 years, whatever the court could grant me would in any event leave me screwed. In practice, urgency is where many urgent cases fall flat. There is something of a presumption against urgency. Suffice to say, it's an uphill battle. In this case, a battle that they seem to have won. So, the fulcrum of this matter is Section 27 of the Disaster Management Act. That's the section that empowers a minister to make regulations. Now, the purpose of the Disaster Management Act is to, well, as the title suggests, manage disasters. It allows the government to take extraordinary steps which would otherwise be bogged down by red tape or other issues in an attempt to help people cope with, survive, and recover from a national disaster. For example, flooding or droughts. I bring this up as the first point of attack in the papers was on the rationality to invoke the Disaster Management Act as opposed to other existing legislation, such as the International Health Regulations Act. Now, I won't go into too much detail, but suffice to say that the Disaster Management Act gives the President and whichever minister he chooses far wider powers than the International Health Regulations Act, so it doesn't really take a genius to figure out why they picked one over the other. The first point of challenge of the applicants was exactly this choice, specifically whether the DMA was the correct choice, and the court said yes, it was. Although the version provided by Dlamini-Zuma wasn't exactly enlightening to the court decided to take into account the novel nature of the virus and said that there was no guarantee that the International Health Regulations Act would be up to task. So as the decision to apply the DMA couldn't be classified as irrational, the next step was to attack the regulations themselves. To quote 4.13, having stated that, though, the declaration of a national state of disaster by the minister had important consequences, it allowed her to make regulations and issue extensive directions regarding a wide range of aspects. End quote. And what wide powers indeed. I won't regale you word for word, but here are some highlights. The government may, release any available resources of the national government, including stores, equipment, vehicles, and facilities. Evict people, tell them to go, where not to go, remove them from their houses, take them to different houses, control traffic, and any other steps that may be necessary to prevent the escalation of a disaster. In short, the government is permitted to make regulations that infringe upon very many of your constitutional rights, all under the auspice of preventing a national disaster. And as you can imagine, with such powers are very open to abuse. Two other points stick out at me, the first of which is section 27, subsection 2I. To quote, "The suspension or limiting of the sale, dispensing, or transportation of alcoholic beverages in the disaster-stricken or threatened area." End quote. What I find interesting about this section is not what it says, but rather what it does not say. See, the section specifically prohibits the sale and distribution of alcohol, but it is silent on cigarettes. Now, I don't drink and I don't smoke, so I don't really have a dog in this race. But I find it interesting that the government elected to limit cigarettes as well as alcohol, although I'll be tackling the smoking issue in an upcoming video, as there is another challenge to these regulations next week. The second thing I find particularly interesting is found in section 27 sub 2L, emergency procurement procedures. That entails that the government is permitted to procure items of whatever nature without following the normal tender process. Now, considering the ANC's checkered history when it comes to procurement, this seems dangerous, and I truly hope that there is a full review of all procurements made during this disaster period. My suspicion is that more than one irregularity, some friend of a cousin, of a high-up minister or ANC-connected cadre will have, just by coincidence, by happenstance, landed a lucrative government contract. But I mean, what are the odds of that happening? Now, normally, when a regulation is made, that regulation must first be approved by Parliament and the National Council of Provinces. There's a rather lengthy process to the whole thing. However, the regulations under the Disaster Management Act is apparently free of such fetters. Generally, one would want these regulations to come out quickly and effectively and save lives, in theory at least. In light of this, the court found that the mere fact that Parliament and the National Council of Provinces don't get to have eyes on this particular regulation is insufficient to declare that regulation unconstitutional, as having lengthy debates on these regulations may indeed have dire consequences, considering the urgent nature of them. However, the court did make a comment in this regard. To quote, "What it does highlight, however, is the consequences of invoking a national state of disaster and reliance on section 27 sub 2. It places the power to promulgate and direct substantial, if not virtually all aspects of everyday life of the people of South Africa in the hands of a single minister with little or none of the customary parliamentary, provincial or other oversight functions provided for in the constitution in place. The exercise of functions should therefore be closely scrutinized to ensure the legality and constitutional compliance thereof." End quote. In other words, the court here recognized that a single person is given absolute power in terms of these regulations. Power to such an extent that constitutional rights are effectively null and void should the minister say so, and those constitutional rights may only be restored upon either the lifting of the regulation or a court challenge thereto. This is basically unlimited power, and that power can be wielded without oversight, without restraint, without questioning, for weeks, until someone brings it to court. By then a lot of damage can be done, quite a lot. But I digress. The Disaster Management Act does have some built-in protections on how this power might be invoked. Specifically, the regulations may only be made after consulting with a responsible cabinet member. Suddenly the ghost of the the incompetent Dlamini springs to mind, as she would have been deemed a responsible member by the ANC. But never mind, it's fine. The power to make regulations and directions may be exercised only to the extent that it is necessary for the purpose of assisting and protecting the public, providing relief to the public, protecting property, preventing or combating disruption, or dealing with the destructive and other effects of the disaster, as set out in section 23.7 of the DMA. In other words, the reasons for which the powers conferred may be used is narrow. It must be used with the purpose of achieving one of these objectives. But then it becomes a matter of semantics. Well, you see, my sister-in-law's cousin has a company that provides medical masks, so we need to buy from them on an emergency basis at, I don't know, like 5 times the normal costs. It's for the protection of the public, you see, it's perfectly fine. I mean, this is a made-up example, but it illustrates the point of how quickly and how easily these objectives and purposes can be subverted. At this point, it should be clear that this power should be able to be tested, and there are 2 tests applied by the court. The first test is the rationality test. It answers the question, to quote, "Is there a rational connection between the intervention and the purpose for which it was taken?" Now, bearing in mind that this test is not whether it is the best course of action, but rather whether there is a link between the cause of action and the objective of the regulation. Returning to our mask example, one must ask, is there a rational connection between purchasing the masks and preventing the spread of the COVID virus? And the answer, without getting into the debate whether or not masks work or not, which is a stupid debate, but fine. The question is there a rational connection? And the answer is, well, yes, there is. And because there are emergency procurement powers at play, I hope it's clear that the Disaster Management Act is perhaps overbroad in the powers it provides. I'm getting into the weeds. Back on track. The second test applied by the court is the limitation test. The limitation test entails whether the action is justifiable in an open and democratic society based on human dignity, equality, and freedom, and is found in section 36 of the Constitution. Basically, we ask, having a look at the democracy that we want to be, having a look at the rights that we hold sacrosanct, is the action justifiable measured against that, and measured against the impact that the action has on the other constitutional rights of the people involved? In other words, it entails a balancing act of rights. The purpose of this test is to ensure that whatever method or action is followed, that it has the smallest negative impact on the rights of those so affected by the action. Now, it is clear that Dlamini-Zuma is, she's enjoyed her powers, and I say this because of how she has chosen to approach these challenges to her power. To quote, 6.7, "I am advised in determining whether the decision of the functionary is rational, the test is objective, and whether the means justify the ends. Thus, I submit with respect that under the circumstances, the means justifies the ends." End quote. Now, this turn of phrase is particularly telling. Classically, it's the end justifies the means. That is to say, our goal is so noble, so important, that it doesn't matter what we do to achieve it. That as long as it is achieved, whatever we've done will be justified. No, not Dlamini-Zuma. She says the means justify the ends. In other words, what we do, our action, is so perfect, so sacrosanct, so correct, that it justifies whatever we achieve. In other words, they argue that the results of their actions cannot be questioned because the actions themselves are perfect and good. Now, I've heard some pretty arrogant things in my life, but damn, Dlamini-Zuma further argues that her actions were in pursuit of protection of constitutional rights, specifically the right to life, access to healthcare, and an environment that is not harmful. If I may interject my own opinion for a moment, we must remember that this is a country with a murder rate that is similar to that of a war zone, and now the right to life is important. We have a public health system that is in shambles, where if you're ill, you have to wait for hours before seeing someone. And I know this from personal experience. On a particular occasion, I took a loved one to a hospital as she was in terrible pain. After waiting there for 4 hours, we just left. No one was willing to help us. But yeah, no, sure, I believe you 100%. Right to access to healthcare, now super important. And an environment that's not harmful. Well, having a look at the quality of water in Pretoria and the fact that it is probably advisable to mix in bleach with your water in order not to die or catch a disease. Yeah, I'm super on board that these things are now suddenly important, and it's got nothing to do with the widespread power and control that you are allowed under the DMA. Once again, I digress. Dlamini-Zuma continues with her argument, saying that any economic hardship suffered, any loss of livelihood, any infringement of freedom of movement is justified because of the right to life of other people. The court responds to this in what I think is a fairly clever fashion. To quote, at paragraph 6.10, an equally anguishing conundrum is the resultant choice between plague and famine. End quote. And I think the judge is correct in phrasing it in such a way. What is the point of surviving this horrible disease only to die of starvation? The judge also makes a point about the fact that this is hardly an easy decision to make, and I also agree with that. Finding a middle road that makes sense and protects as much rights and protects the economy and ensures that half the population doesn't die out is not an easy task. But unfortunately, the decision made by Dlamini-Zuma, well, didn't quite strike the balance, did it? The next step the court takes is applying the rationality test to the regulations in order to test whether the regulations are rationally connected with the purposes of managing COVID. Before I made the comment that I wished that the judgment was more clear, it was this portion of the judgment that I was specifically referring to. Now again, here I must come to the judge's defense once more. This was an urgent matter, there wasn't particularly over much time to prepare a proper in-depth judgment. It's just the nature of things. But again, I can't help but wish that it was a bit more succinct and precise, if only to eliminate a otherwise needless point of appeal. But I'll get to that when I talk about the consequences of the judgment. The judge then continues to raise points which he feels do not meet the rationality test, that do not support the objective of halting the spread of the COVID virus. One example he used was a hairdresser who is not permitted to ply her trade, who must watch as her children go hungry, all for the reason that being in such close proximity might, spread the virus a bit. Meanwhile, it's perfectly fine for a taxi to transport 8, 9, 10, 12, 15 people. But that's not close enough proximity, it's fine. It's okay. This also serves as a good illustration as to how the rationality test is applied. So why is it okay for one but not the other when the other is actually worse than the one? Therefore, it's not rational, and the challenge against it ought to succeed. Another example raised by the court of the illogical nature of these regulations is you are not allowed to go to a family member who is ill or requires assistance, like a mother or a grandmother who's particularly old. But once she passes away, then it's fine, then 50 people can come and then have a funeral. It doesn't make sense. Another example is with the exercise. You're allowed to jog between certain times, but magically after 9 a.m. in the morning, then the virus gets super dangerous. Or, you can jog on the promenade, but the moment you put your foot on the beach, it's time for jail. Can't run on the beach. The virus is very dangerous on the beach. Apparently, the minister further attempted to justify her actions by saying that, no, the government can provide some monetary compensation for the infringement of people's rights. But we know from practice and from the practical application of this thinking that apparently if you are not black enough or if you don't have BEE compliance, sorry, no support, no relief for you, sucks to suck. And on the point of that, you have these food lines, and I understand that people aren't allowed to work, there's no money coming in, you need to eat. It's logical. But if you look at the footage of people standing in these food lines, in these lines, social distancing is effectively non-existent, and people are standing there for hours and days. And again, to support my allegation that this whole thing is just one massive power trip, the government has said that you can only buy certain sorts of clothes. I mean, at one point you were allowed to buy a jersey or a jacket, but not underwear. And I mean, last time I checked, most companies allow you to take a jacket or a jersey back if it doesn't fit. And if you're an infected person, that will spread the infection to the next person. But most places, as far as I am aware, don't have the same rule with regards to underwear. So, underwear is probably more safe? Again, digressing. The court held that despite the myriad of irrational regulations, there were still many that were rational, like the closing down of gyms and clubs. As far as my understanding of the COVID virus goes, it spreads through body liquids such as sweat, for example, and it would make sense to close places where people sweat. The court further found that there is no evidence before it that the minister considered the impact on the constitutional rights of the people of South Africa before promulgating and implementing these regulations. To quote, paragraph 7.17, the starting point was not, how can we as government limit constitutional rights in the least possible fashion while still protecting the inhabitants of South Africa, but rather, we will seek to achieve our goals by whatever means, irrespective of the costs, and we will determine, albeit incrementally, which constitutional rights you as the people of South Africa may exercise. End quote. Again, if it walks like a duck, quacks like a duck, it's a power trip. Let's call it what it is. It's a power trip. In any event, Dlamini-Zuma's counter-argument to all of this is, and I quote, the power exercised under lockdown regulations are for the public good, and therefore the standard is not breached. End quote. Again, our objectives are noble, our actions are noble, and it's big no-no for you for wanting to question them. And I mean, while we're busy with no questions, ignore the fact that we've deployed the army to control people. The army, an organization, that exists to kill people. Not like the police, whose job it is to, police people and ensure that people don't get killed. We're going to bring the people that exist to kill. Yes. Right, a couple more aspects are handled in the case, but they're fairly minor and innocuous. So let's move on to the conclusion and the ultimate order. First order, the regulations published under section 27.2 of the DMA is declared invalid. Now it's important to note that only the regulations are declared invalid and not this section. That means that further regulations may be promulgated in future. A little worrying, but the court has already corrected for this. It requires as its second order for the minister, after consulting with relevant cabinet ministers, review and amend and republish the regulations. Now, she is specifically ordered to give due consideration to the limitation each regulation has on the rights guaranteed in the Bill of Rights contained in the Constitution. Based on the fact that she hasn't really done that thus far, And again, her mentality of, well, I'm right and you can go jump off a cliff, but not at a beach because then you'd be breaking regulations. The court has said in their third order that the minister must take the necessary steps to republish and reconsider and reconsult within 14 days, but she must also bring these regulations back in front of the court so that the court can ensure that due consideration was given. The court further found that simply depriving the country of any and all regulation would lead to chaos, and I do agree. So the regulations as they stand at the time of the bringing of this application, that is to say Alert Level 3 regulations, remain in place for at least 2 weeks. And at least 2 weeks is an important phrase here, but I'll get back to that in a moment. Right, final two orders. The sale of tobacco is not being considered by this court, as there's another matter that will be coming, well, basically next week. The final order is that the minister is to pay the cost of the first and second applicant. I would have preferred a more heavy cost order at instead of party and party scale to party and own client scale. But well, the court decided that this is what it is. It's not ideal, but fine. Actually, what I would have wanted is that the minister be ordered to personally be held liable for the costs, as I think that's the only way to really enforce compliance from the ANC. Seeing as there's no political consequences, there might as well be financial ones brought on through the judiciary. Just a thought. This recording has gone longer than I thought. It was supposed to be a 5-minute discussion. Oh well, in for a penny, in for a pound. Let's quickly touch on the post-judgment realities. For the next 2 weeks, basically nothing happens. Dlamini-Zuma must do her thing or not do her thing and then face the consequences. If she does a piss-poor job, she might be held in contempt of court, which entails either a fine or jail time. If she doesn't do anything, pretty much the same. My suspicion is that she'll come back and be like, oh no, I was so busy managing things, I couldn't get to this. Oh, and I had another case. Can you which I hope the court throws her in jail for a good month or so. Really give her the time and space she needs to consider the impacts of her regulations. But I could dream. Plus it would be funny. Oh, I would laugh. Regardless of how things proceed, this is not the end of this matter. A declaration of constitutional invalidity may be given by a high court, but it must be confirmed by the Constitutional Court. Plus, there's the opportunity for the government to appeal. They've got unlimited money to challenge these sorts of things, so obviously they'll appeal. If things are permitted to take their natural course, it'll end up in front of the Constitutional Court in any event. And in front of that court, the minister will be permitted to place her counter-arguments again, as is her right. However, there is the possibility of an appeal. Now, whether this appeal will happen before the 2-week time period is up or after it, I don't know. It depends on whether the government wishes to bring finality to this matter or drag it out as long as they can. Again, we sit with a ruling party that is immune to embarrassment, that is immune to consequences for the most part. So it's well within their modus operandi to try and kick this out for as long as they can. And remember, there can be no de-escalation to level 2 as long as this exists. So I'm very curious to see what will happen, how it will happen. And if I were a betting man, I'd say that, well, Dlamini-Zuma is the sort of woman that will want to keep her power intact for as long as possible. Consequences be damned. My penultimate point has to do with a comment made by another legal practitioner. He mentioned that there could be damages if the regulations are declared unconstitutional. I don't believe this to be the case. The reason I say so is that Section 61 of the Disaster Management Act provides indemnity against damages for any regulations, as long as they were in good faith. Considering the scope of potential damages claimed, I doubt that any court would lift the indemnity. It would mean the destruction of government as an entity. It would crash the economy further than it is right now. So having to choose between the rights of citizens and the existence of South Africa as an independent state, yeah, I don't think that's going to happen. I don't foresee that as a possibility. Right, conclusion and final thoughts. Good judgment for what it is, not as clear as it should be. I would have liked an itemized or tabled list of regulations just to make it easy and leave less wiggle room. Because such a table isn't there, it might be open for appeal. The fact that there might be an appeal, that is a little worrying, but knowing what we know, I wouldn't be surprised. The question is then, will there be any actual impact from the judgment? And the answer is probably not. We won't see a difference in our levels until 2 weeks from now. If they appeal it, we're looking at months more of level 3, which is the goal. Couple that with the fact that the ANC is not particularly keen on political consequences for its less than well-performing ministers. I submit that the judgment can be summarized as follows. Good in law, but potentially moot in practice. Oh well, time will tell. Until next time, I'm Advocate. Thanks very much for watching.